This is about how people who are already living in the United States legally get green cards, and why a quiet but major policy shift could force many of them to leave the country just to finish the process. To understand why this matters, you need to know there are two main ways to get a green card. One is called adjustment of status. That means you apply from inside the U.S. You stay here while USCIS processes your case. You can usually work, travel with permission, and stay with your family the entire time. This has been the normal path for decades for spouses of U.S. citizens, many workers, and others who qualify. The second way is consular processing. That means you leave the United States and finish your green card application at a U.S. embassy or consulate abroad. If everything goes perfectly, you come back as a permanent resident. But leaving the country is where the danger starts. The concern raised in the Reichland-Melnick thread is that USCIS is changing how it treats adjustment of status. Instead of treating it as a standard process Congress created, USCIS is signaling that adjustment should be treated as rare, discretionary relief. In plain terms, even if someone qualifies under the law, officers may be told to deny more cases or push people to apply from outside the country instead. This is not Congress changing the law. It's a change in interpretation and guidance. But because USCIS decides hundreds of thousands of these cases, small wording changes can completely reshape outcomes. So why is forcing people to leave such a big deal? First, family separation. If a spouse or parent has to consular process, families can be split for months or years. Some consulates have massive backlogs. Others barely process immigrant visas at all. Second, and more serious, are the unlawful presence bars. If someone has been in the U.S. without valid status for more than 180 days, then leaves, they can be barred from returning for 3 years. If it's over 1 year, the bar is 10 years. That means a person can be legally eligible for a green card, but the moment they leave to apply, they trigger a punishment that keeps them out of the country for a decade unless they get a waiver. Waivers exist, but they are slow, limited, and discretionary. Many people do not qualify, and approval is never guaranteed. So telling someone to just apply from abroad is not a neutral alternative. It can be life-altering. There are also practical risks. Consulates face staffing shortages, security checks, and administrative processing delays. Some countries barely offer appointments at all. People can be forced to leave the U.S. to process a visa in a place where processing is effectively unavailable. Who does this affect? Not people sneaking around the system. It affects spouses of U.S. citizens, long-term residents, workers stuck in visa backlogs, and families who have followed the rules for years. These are often the people the legal immigration system is supposed to protect. That's why analysts are alarmed. This isn't one dramatic announcement. It's policy drift, administrative discretion quietly replacing predictable rules. When adjustment of status becomes harder to access, legal immigration becomes more fragile, families become more vulnerable, and trust in the system erodes. The plain English translation of the thread is this: the government may be making it much harder for people already here to finish getting green cards, pushing them to leave the country, even though leaving can mean years of separation or permanent exile. And that shift, while technical, has enormous human consequences.